Your last matter be Mr. Everidge?
It is, Your Honor.
Okay, we'll call People v. James Everidge, file 24-6907FH. Here for sentencing on a charge of operating while intoxicated, third offense. Counsel, please state your appearances.
Melissa Goodrich, Blaine County Prosecutor.
Dr. Amber Libby, Your Honor, on behalf of James Everidge, who's making his way to the defense table here to my right.
All right, I guess I'll indicate a couple weeks ago I did sign a warrant for Mr. Everidge's arrest for a positive reading on the sober link. He did not have police contact or a court date, which resulted in his being taken into custody. So he's here for sentencing anyway. So I guess at this point, I'll just recall the warrant. But we did have a couple, well, it was a 7 p.m. Positive 0.014, and then several missed tests after that. All right, so I've been handed here some letters to take these. Do you have any information why Mr. Everidge, who's got a Sheboygan address, is submitting a letter about his substance use evaluation from Maryland?
Your Honor, my understanding is Mr. Everidge did his evaluation online, and that institution is accredited through Maryland.
All right. I've had a chance to review those documents. Have you had a chance to review the report, pre-sentence report and recommendations with your client?
I have, Your Honor.
Any additions or corrections?
Just one general objection to the scoring, Your Honor. There's no change to the scoring as a result of this objection. It's to OV12 is scored at 1 point. Our objection is the categorization for a contemporaneous felony criminal action appears to be based on the weapon allegation, which was dismissed. And I believe in OV12, there's a prohibition against the possession of a firearm during commission for the point assessment there. So I'm just placing that objection on the record.
Well, the fact that it was dismissed wouldn't be dispositive because uncharged conduct can be the basis for OB12, but you're saying there's something about not scoring. Oh, possession of a firearm during the commission of a felony. Okay, it doesn't score. Okay, that's the, okay. So a felony firearm charge can't score. Ms. Goodrich, what's the people's response?
OB12 does cover, actually, it only applies because it didn't result in a separate conviction. So I think that was appropriately scored. Yeah, it occurred within the 24 hours.
Okay, well, and even if it didn't apply then to the felony firearm charge count 3, count 2 was a carrying and concealed weapon, and that would be scoreable under OB12. So I'll overrule that objection and leave OB12 scored at 1 point. Ms. Goodrich, do people have any scoring challenges or additions, corrections to report?
No, Your Honor.
Ms. Libby, anything you'd like to say on behalf of Mr. Everidge?
Yes, Your Honor, thank you. We've received and reviewed the PSI in this case, and we are asking the court to adopt the recommendations therein. Mr. Everidge is before you at age 75, about to turn 76. And part of what I've learned through my representation with him is this cross-generational understanding of the world and their difference in perception and communication. For instance, in the last 75 years, Mr. Everidge has lived through 15 presidential administrations, if I did my math correctly, and vast changes in the economy, for instance. And the current OWI laws that we're here on today were enacted in 2003. In Mr. Everidge's adolescence in the 1960s, NHTSA was still advocating to the legislature that there was a danger associated with the full crime of driving while inebriated. The reason I bring this up, Your Honor, is the mentality of today is that we take for granted common knowledge that OWIs are inherently a public danger, but it wasn't always that way. And yet, despite his generational difference to myself or anyone else at a younger generation, he's taken on a willingness to learn and grow and change, as hard as it may have been, away from alcohol use and away from the understanding that driving under this condition is a rite of passage, to today when it is a crime and carries an inherent danger. Since being placed on bond over 4 months ago, Mr. Average has been compliant and cooperative, learning today of an incident the court has on its records, but he has been diligent with the tedious requirements of SoberLink, and they've been challenging at times. He's certainly experienced a learning curve, especially with regards to retesting, which we've walked through. But as the court has reviewed the assessment from the Freedom Center dated August 16th, just days after his arrest, indicates no active substance use disorder. They have a recommendation for a drug and alcohol education course. And this is positive for this court's consideration at sentencing today, because it doesn't appear that Mr. Average is battling with addiction, but rather needing to learn new behaviors. From my review, his contacts with the criminal justice system for this type of offense have happened in the last 5 years, beginning late 60s for him. And he comes before you as someone with a 34.5-year career in a chemical factory. Unfortunately, that's resulted in asbestosis for him. There is a letter included for the court from Dr. Lee J. as to that condition. And notably for Mr. Average, he has been married to Linda for 56 years. This is a testament to his commitment and compromise as a human being. The court also has a letter from his daughter, Debbie, which highlights her father being committed in her life. And she's currently battling stage 4 cancer and has had to rely on other mediums to maintain a bond with her parents. Lastly, Your Honor, the court has a letter from Deanna, Mr. Average's other daughter, and she reports a similar positive childhood unaffected by alcohol. I'm asking the court to take a look at Mr. Average individually here before you today. I'm asking the court to adopt the recommendation, and I thank the court.
All right, thank you. Mr. Everidge is not required to tell me anything today. It's allowed. Is there anything you want to tell me or no?
Yes, sir, I would. Oh. I'm not used to these procedures.
Well, you've had a couple before. This is your 3rd conviction, so you're a little bit more familiar than people who haven't committed any crimes.
I don't want to get familiar with one. Let's put it that way.
Well, it's your 3rd time up.
Anyway, with that .00, what was it, 2 or 007?
Yeah, ignore that. I'm disregarding that, sir. I told you I'm recalling the warrant. I'm disregarding that.
Okay, well, I don't know what happened.
Well,
Since I was arrested, I have not consumed one single drop of alcohol, not one. And my family doctor has told me that those things are not dependable.
What do you want to tell me about your case or your situation?
Well, since I've been going through the court procedures, my acquaintance with my wife is extremely better. Both my daughters sent letters of recommendation and stating my personality. I have changed. I look forward to going out in my garage in the day and working on my side-by-side, as you can see with my fingernails. I'm a changed person. I'm just a changed person for the better. I will never, regardless of what you do, I will never drink a drop of alcohol again.
Why didn't you decide that in 2021 when you were convicted of drunk driving?
I don't know.
Or in 2019 when you were convicted of drunk driving?
I can't answer that.
So you forgive me if I don't necessarily believe your profession of never going to drink a drop again today.
I would say that I made a error in judgment.
Thanks, sir. Ms. Goodrich, people's recommendation.
Yes, Your Honor, the defendant is 75 years old with no prior felonies and 2 prior misdemeanors. I would like to address the recent past. He started his criminal history at 63 years old. He's incurred these 3 drunk drivings in just the last 3 years. The first drunk driving, he received 30 days incarceration. That drunk driving also involved carrying a concealed weapon, it appears. His second, and that was in 2019, his second drunk driving, he received 5 days of jail, and that was in 2021, involving a high BAC. And now here we are already again on August 2nd of 2024. He again is drinking and driving while having a weapon on him, which certainly escalates the public safety concerns that already surround the drunk driving law. I would ask that the goals of deterrence, rehabilitation, and being punitive would be properly addressed by adopting the recommendations of the PSI, but giving incarceration, since the 30 days did not work, the 5 days did not work. I would ask for 3 months jail, which would be mid-guideline range. Thank you.
Thank you. Mr. Everidge, if you please stand for the court sentence. All right, well, Mr. Everidge is 75 years old, has no prior felonies. That's all to his credit. There are, however, there's room for concern here. In the last 5 years, this is his 3rd drinking and driving conviction. So therefore, the attitudes about drinking and driving when Mr. Everidge was 20 years old, I'm glad as a society we've grown from that. And Mr. Everidge has certainly had every opportunity to correct his attitude and behavior about that. Like I said, this is your 3rd time at bat coming in front of a judge for drunk driving.
Yes, sir.
It gets worse each time. And, unless you want to spend, your sunset years in a prison, I hope you mean it that you're done drinking, because otherwise you're going to keep seeing judges like me, and it's really going to go badly for you.
Yeah, no, sir, I am done.
All right. Well, there are some fines and costs here. $68 in state cost, $130 in crime victims assessment, $350 in court costs, $500 fine, $60 for DNA testing fee. We comply with that. I'm going to order that the weapon that was seized is forfeited to the agency that seized it. I'm going to place you on probation for 18 months, subject to the terms and conditions listed on pages 2 and 3 in the pre-sentence report, with the exception that I'm going to strike the requirement for community service because of the letter from the doctor that he's unable to comply with that. There is a mandatory minimum of 30 days in jail by the statute. And you've already had that assessed once in the past, and the guidelines of 0 to 3 months. I think there's grounds for incarceration in this case, given the mandatory minimum by law, and also the fact that this is the 3rd offense within less than 5 years. So I am going to adopt the prosecutor's recommendation and order Mr. Everidge to 3 months in the Sheboygan County Jail forthwith, with credit for 3 days previously served. That's the sentence of the court. Mr. Everidge, if you wanted to appeal, you can file an application to the Court of Appeals. If you wanted me to give you a lawyer, I would, but you'd have to ask me within 6 months. We're going to ask you to initial 1 copy of your appeal rights, so we have a record and gave it to you. The other one is for you to fill out if you want to take an appeal. Within 24 hours of your release, you have to contact your supervising agent.
Your Honor, we'd also ask that the gun be forfeited.
Yes, the judgment will indicate the weapon will be forfeited to the agency that seized it. All right, good luck, sir. Does that conclude your matters, Mr.?
It does.
Okay, thank you.
Thank
Mr. Cananti on Zoom. Oh, Mr. Bradshaw's in jail. Well, let me see if what we're doing for this.
You follow him?
All right, and up next, we've got People v. Robert Bradshaw, file 24-6937.